Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hey fam, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk. Y'all, so we have to tap on into this Jeffrey Metcalf and Meghan Metcalf divorce out of the 429th Court of Collin County. So there has been rumors, I don't even know what to call it. There's been a lot of misinformation that has been presented on YouTube and social media about the 429th judge, Miss Jill Willis in Collin County, and everybody is in an uproar. I'm talking like this because I'm just flabbergasted. Everybody's like, well, she should recuse herself, so on and so forth, and I am in a war on Instagram saying she didn't have to recuse herself, for one, based off of the Texas Rules of Civil Procedure 18B, but two, if you read the full docket, you'll understand that it was an uncontested divorce. And my question to people was, why did she need to recuse herself? Oh, because she knew the Metcalfs. It was an uncontested divorce. Even if the divorce played out, I would understand that yes, she would need to recuse herself if one party felt that, if she automatically knew that she was not going to be fair to either party. It would be different if it was a contested divorce and they were arguing over custody and assets and things of that nature. And she would have says, okay, well, I knew Jeff way longer than I knew Megan, and I feel like I'm not going to be fair to either of them. Then of course I will go ahead and recuse myself. It wasn't a contested divorce, people. It was uncontested. And people have this misconception that when they file a document, it goes and it's placed on the judge's desk. I'm going to go through the process. We're going to go through the Texas Rules of Civil Procedure. We're going to go through the process for an uncontested divorce, and then I'm going to show y'all the docket. And that's going to be it. However you formulate your own opinion, however you draw your conclusion, however you make your inference, that's on you. The only thing I can do is I can show you and I can explain. Now, what makes me qualified to explain? Because I draft divorce documents in the state of Texas and I file in counties, including Collin County. And I know specifically what the judges do in an uncontested divorce, especially in Collin County. I have done, I don't even know how many uncontested divorces I've drafted and filed. And because both parties are pro se and they agree on everything, they don't have to step foot in a courtroom. They don't have to go before the judge. Let me explain. Now, I'm going to explain first the Texas Rules of Civil Procedure 18B when I pull my screen up. Give me some time. Okay. Texas. I should have just typed because I don't feel like. Let me just do 18B. And you guys can actually do this yourselves. Everybody use Google for everything else except for the right thing. Grounds. And let me do this a little different so you guys can see this. This is grounds for disqualification and recusal of judges. This is the Texas Rules of Civil Procedure that everybody in Texas who are currently in a civil suit. I'm not talking about criminal. Criminal have their own set of procedures. Civil, family law specifically, have rules that they have to abide by, but these are just civil. So it doesn't matter car wreck, personal injury, any civil matter. These are the rules. Grounds for disqualification and recusal of judges. Disqualification, number one, says judges shall disqualify themselves in all proceedings in which they have served as a lawyer in the matter in controversy, or a lawyer with whom they previously practiced law served during such association as a lawyer concerning the matter, or B, they know that individually or as a fiduciary they have an interest in the subject matter in controversy, or C, either of the parties may be related to them by infinity or consanguinity within the third degree. Then you have the second paragraph that says recusal. Judges shall recuse themselves in proceedings in which their impartiality might reasonably be questioned, including but not limited to instances in which they have a personal bias or prejudice concerning the subject matter of a party, not parties, but of a party, or knowledge or personal knowledge of disputed evidentiary facts concerning the proceedings. So if it was a contested divorce and they had a final hearing and they had to go before the judge, and she knew, let's say she didn't know them personally, right? She would need to recuse herself and say, "Hey, I knew Jeff longer than I knew Megan. Like, me and Jeff went to school. We graduated in the same class. So I don't think that I will be fair in this situation, and I don't want Megan to feel like I wouldn't be fair. So I'm going to go ahead and recuse myself." But again, I'm saying hypothetically, if that was a contested divorce. But again, it was uncontested. Now, to break this down in the most simplest terms, impartiality concerns, okay, for those who think that a judge will have to recuse herself if she felt like she could not be reasonable, okay? If she felt like her impartiality is going to be questioned by either party, she needs to recuse herself. If they have a personal bias or prejudice concerning a party or the subject matter, if they had any prior knowledge of any of the facts concerning the procedures, if they had a financial interest, family ties, either by marriage or by blood, she would need to recuse herself. If she ever served as a lawyer for either one of them previously in that particular matter, in the divorce, she would have to recuse herself. So I see a lot of people on Instagram saying she needs to recuse, she should have recused, she should have recused, she should have recused. For what reason? Based off of this, for what reason would she need to recuse herself in an uncontested divorce? Please note, oh, you know what? And that's going into the next thing that I want to talk about is the timeline. So in the state of Texas, hold on, let me divorce packet, Texas. In the state of Texas. Now for me, I have my own templates that I use to draft these documents. But if you are a pro se client, self represented, you don't have to have a, you don't have to have anybody. You don't have to have a lawyer. You don't have to even hire a paralegal to draft the documents for you. You can simply do it yourself. There is a step by step guide on Texas Legal Help, and you can pull the documents yourself. You can pull the uncontested, and I'm going to say that the agreed divorce documents yourself. All they had to do was fill this out. So here's the process, and I'm not saying specifically for the Metcalfs, I'm telling you in general. The petition is filed. The file clerk for the district, the Collin County District, the file clerk, not the court, but the file clerk for the district accepts the filing. It is assigned to a court. Once that court is assigned, that petition goes to either the court clerk or the court administrator. It doesn't go to the judge. I'm specifically talking about Collin County as of right now for uncontested divorces. They create a file and that starts the clock. They send out their correspondence saying, hey, you're pro se, blase, blase, blase. These are the dates. This is when it's due, so on and so forth. Once the petition has been filed, each party, well, the petitioner will get a copy of that via email. So two ways he can file it. He can either electronically file it or he can go to the district clerk's office and file it. Notice I'm not saying to the court. He can go to the district clerk's office and he can file it. Once it's filed and he gets a file stamp copy, he has to then serve her. The other option would be for her to file a waiver of service saying, okay, I waive my rights to being served by a process server or a constable. That must be filed within that 60 days. Now, from the time the petition is filed, there is a mandatory 60-day waiting period in the state of Texas. On the 61st day, what I do as a paralegal is I file the remaining documents. So in Collin County, I will file a prove-up affidavit. An prove-up affidavit is pretty much equivalent to them standing before the judge saying, okay, this is why we're wanting a divorce. We was married here on this day, we separated on this day. She gets that, I get that, we both agree. Bam. That's the purpose of that prove-up affidavit. I also filed on that 61st day the final divorce decree. On that day, so when I file it with the file clerk. The file clerk then forwards it to the court clerk or the administrator. Then the whoever is handling the court clerk or the court administrator, they're going to pull that file and say, okay, here's the petition. Here's the response filed by the respondent. Here's the prove up affidavit. Here's the final divorce decree. I have everything that I need. Now I am going to forward this to the judge for signing. And it's as simple as that when we're doing Collin County. And I'm just saying Collin County because that's where all this debauchery is coming from. So the judge don't see that document, those documents, until it is filed. Nothing is for is when a petition is filed, that is not sent to the judge directly. When you file any other pleading, it's not sent to the judge directly. And I am just speaking on Collin County courts, family law court. Okay? So on that 61st day, when I filed that prove up affidavit and that proposed final divorce decree, that's when all the documents go before the judge. She reviews the prove up affidavit. She reviews the proposed final order, and if everything looks good, in which it always is, then she signs it or he signs it, give it back to their court clerk or administrator. They docket everything, make sure, order entered, divorce granted, so on and so forth. And a copy of that file stamp will go to the parties. That's it. 60 days, you can have a divorce if it is agreed or uncontested. The judge will not have any knowledge of anything until the final hearing. Well, I'm going to take that back. In this particular case, until we file that prove up affidavit and the final divorce decree, they're looking to see that you drafted this final divorce decree in accordance to the civil rules of procedure. But that is the only time that she would have touched that file. Now let's go to the docket so I can walk y'all through. I'm not going to keep y'all long. I'm going to show you the first case, and then I'm going to show you the second case. So while I'm pulling this up, when a case is filed, it is filed in the district clerk's office with the file clerk. It is then forwarded to the assigned court. So here is what everybody is seeing. This is what everybody is seeing. Now, I'm not going to go too much further, only because there is information, their address is on there. And whether or not it's current, I don't want to, that's how I run my ship over here. You can't tell me how to run my ship. So this is the matter that they are speaking of. Now, if I scroll further down, you're going to see where the original petition was filed on 7/28/2014. There was no movement on the case. No answer was filed, nor was the waiver of service filed. So what happens is, even when the case is assigned to that court, they send out correspondence. So they would have, the Metcalfs, or Jeff in this matter, would have received correspondence saying that this case is going to be placed on the dismissal hearing. The dismissal hearing docket is called, we call it a DWOP, if there is no movement on the case. And that's exactly what happened. There was no movement on the case. All this case was a petition was filed. Well, it was assigned to a court. Well, how can I say this? The petition was filed to create this case. That's it. That's all. So all the court would have, not the judge, but the court administrator would have, is just a petition petitioning the court for a divorce. The only thing that, and if let's say that Miss Jill did look at the divorce and she said, "Oh, that's Jeff and whatchamacallit," they didn't do nothing on the case. And if they did, it was uncontested. Why would she have to recuse herself on a divorce where they have already came to an agreement on? How can she be biased and they agreed on everything? Please help me make sense on that. All right, so now I'm going to go back, and now I am going to go to their 2016 case, where this one was actually granted. Now this, again, now on this matter, Meghan filed. She was a petitioner. And I'm assuming Jeff said, okay, I'm going to sign the waiver of service, because there's no waiver of service on here. So I'm just assuming he signed the waiver of service, bypassing being served by a constable or the process server. Okay. 60 days passed. After those 60 days, a proof of affidavit was filed along with a proposed final divorce decree. And that was filed on May 16th, 2016. That is the day that the court clerk or the court administrator said, okay, I have the petition, I have the waiver of service, I have the proof of affidavit, and I have the proposed final divorce decree. I am going to go ahead and forward this to the judge for review consideration, meaning that for them to sign. How do I know all this? Because on the 61st day, I filed the proof of affidavit and I filed the proposed final divorce decree. Now, technically, now Collin County is fast. They come back within a week. Within a week, the judge has already signed the agreed proposed order. But sometimes it just all depends on what the judges have on their docket. So I will call and I would say, hey, what's the status on the proposed order that I filed on such and such date? And it was like, well, the judge is still reviewing it. I did forward it to them on this date. So whatever date the court administrator forwarded to the judge is the date that the judge reviews everything. And if everything is fine, they will go ahead and sign. That's what happens in the uncontested divorce cases. Dallas County is a little bit different because when you're pro se, some of the judges require you to come in and go before them. But Collin County is the smoothest county. I love doing divorces in their county. Uncontested, agreed divorces because they're quick and they're smooth. But to get everybody on the same page, this judge, Angela Tucker, Jill Willis, none of them are going to see a self represented party in an uncontested divorce. So, my question is, even if the divorce happened in 2014, what would have been the true reason based off of the Texas Rules of Civil Procedure and the fact that it is an uncontested, it's agreed divorce? What would be the reason for Jill Willis to have recused herself? There's no conflict of interest there, none whatsoever. None whatsoever. Y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Bye bye. Hello.